now for our next news special report.
Breaking tonight, a legal bombshell drops as Missouri fires back at New York. Attorney General Andrew Bailey's lawsuit could change everything about the Trump conviction. But that's not all. A Senate candidate's bold move adds fuel to this constitutional fire. So what does it mean for the 2024 election, and why should every American, regardless of party, pay attention? Well, stay tuned for the full story and my final thought that'll have you rethinking everything you thought you knew about this case. Now, before we dive deeper, let's talk about protecting your future. Just as Missouri is fighting to protect our republic, you need to safeguard your wealth. Gold soaring past $2,400 an ounce, not because it's getting pricier, but because our dollar is getting weaker. It's like the New York case against Trump. The real story is beneath the surface. As countries consider dumping the petrodollar agreement, your purchasing power is at risk. Don't wait for a financial verdict you can't appeal. Call Global Gold Investments at the number on the screen. Pause the video and write it down, 888-700-4148. Mention our show for VIP treatment and get their Insure Your Money Guide free. That's 888-700-4148. Now, back to Missouri's legal counterattack. Now, it started with the Professor Jed Rubenfeld. He recently made waves when he outlined a pathway for President Trump to appeal his New York conviction directly to the Supreme Court before the 2024 election. Speaking with Vivek Ramaswamy, according to Rubenfeld, other states could sue New York for preventing Trump from being able to fully campaign in their states. This would land the case immediately in the Supreme Court. Now, Rubenfeld argues that labeling a presidential candidate a convicted felon could alter the election's outcome, causing what he terms irreparable harm. He believes a federal court must review the serious constitutional objections to the New York case. Watch.
You brand somebody a convicted felon, that could, change the outcome of the election. That could affect the election of the next president of the United States, and we'll never get a federal court to actually rule on these serious constitutional issues until long after the election. That's, in legal terms, that's irreparable harm. And that's why I've said that, if I were the lawyer for the Trump team right now, I'd be running to federal court right now, file suit under Section 1983, and say, you got to pause those proceedings in the state criminal courts, and we got to give a chance for the federal courts to review these serious constitutional objections. Now, it gets harder and harder to do. Once you've got the jury reaching a verdict, it gets harder and harder to claim that a federal court can hear this case. You have to overcome certain abstention doctrines and other doctrines. But I think there's actually some good arguments that in these extraordinary circumstances, a federal court should look at this to avoid irreparable harm. And that can actually be done fairly quickly. You move for a TRO, an emergency temporary restraining order, whichever way the judge comes out on that. You could appeal to the Second Circuit, and whichever way the Second Circuit comes out on that, that could go to the Supreme Court. That could all happen on a kind of a fast track basis. I wish we could get a federal court to hear this, because the country kind of needs that. You can't just have this kind of thing resolved by New York courts deciding the case under New York law. They should be looking at constitutional law, but so far, as far as I can tell, Judge Mershon hasn't really been doing that.
And could the Supreme Court itself make that determination right away? Or,
well, I'll tell you,
ordinarily they would wait to run its way through New York, but they could just take and grant cert now.
Well, it's conceivable. There are certain emergency doctrines you might try to take advantage of, but no guarantee. It's tough. Yeah. I'll tell you what, though. If another state sued New York, there's only one court in the country that has jurisdiction, exclusive jurisdiction, over a suit by one state against another, and that happens to be the United States Supreme Court. They cannot bring their case in a state court, a federal district court. You can only bring that case to the United States Supreme Court. A state attorney general, in principle, could bring a case against the state of New York right now and say, this is an unconstitutional conviction. And, we know what you're going to do is very likely you're either going to incarcerate or impose probation. That's, very, very likely. And that's going to hinder Trump from campaigning in our state. And that gives us an injury, and that gives us standing. And we want to litigate whether this conviction was constitutional. That's a long shot. But
I kind of like that a lot, actually. It's very interesting.
It could be done.
And now the Missouri Attorney General Andrew Bailey is putting this strategy into action. He's filed a lawsuit against New York, accusing them of launching a direct attack on their democratic process through what he calls unconstitutional lawfare against President Trump. Take a look.
Hi. Mr. Attorney General, you're planning to sue New York State over their criminal case against Donald Trump. On what grounds are you suing them?
Well, the state of Missouri and the voters of Missouri have a sovereign interest in having access to, that means physical access to and hearing from a presidential candidate for the top office in the United States government. And you've got leftists in blue states committing lawfare, unfounded lawfare against President Trump and denying Missourians of access to their chosen presidential candidate. Millions and millions of Missourians have voted for President Trump and deserve the ability to be able to hear from him. We can't let states like New York deny Missourians of access to that candidate.
Well, surely those charges, that conviction will be thrown out, won't it?
Eventually, but it'll be too late. It'll still have interfered with the 2024 election. Yeah. Let's take ourselves back to 1860. Would we have allowed a Southern rogue prosecutor to take Abraham Lincoln off the campaign trail prior to the Civil War on specious legal charges? No, we would not have. And this is no different.
I guess it takes the law to fight back against lawfare. Andrew Bailey, Missouri Attorney General, thanks for joining us, sir. I know we'll see you again.
Now, what you see on the screen here is a tweet from A.G. Bailey announcing his lawsuit against New York. He's taking a stand against what he sees as an attempt to interfere with the 2024 election. Now, Bailey didn't stop there. In a follow-up tweet, he doubled down on his commitment to fight back. Now, it emphasizes Bailey's determination to counter what he calls a rogue prosecutor trying to derail a presidential candidate's campaign. He argues this action sabotages Missourians' right to a free and fair election. Now, Bailey's lawsuit could fast-track the case to the Supreme Court, as the highest court has exclusive jurisdiction over lawsuits between states. Now, this move aligns with the suggested strategy, potentially offering Trump a path to overturn his conviction before the 2024 election. But the fight doesn't end there. Constitutional lawyer and U.S. Senate candidate Jonathan Emord has stepped into the ring. He's announcing his plans to file an amicus brief on behalf of the MAGA caucus and other concerned groups. Now, he argues the trial was a sham and infringes upon the First Amendment rights of both Trump and his supporters. At a recent Free Trump rally, he passionately made the declaration. Watch.
So how do you take action in Donald Trump's case? Well, this is how you do it. You do it through an amicus brief. Now, what is an amicus brief? It's a friend of the court brief, routinely accepted by courts across the country. And in that brief, we can argue things and explain things that are part of the record that the parties in the case will not devote time to. And we can explain the ramifications of this. What does it mean for us, those who are in the MAGA caucus? What does it mean? It means that they who are Trump supporters, and there are many other groups in Virginia too that are joining in this, it means that they who are Trump supporters are not able to interact with their client, with their candidate, if he is incarcerated, if he is subject to detention. And the restrictions that have already taken place with this sham trial have denied them that right too. Why is it a right? Under the First Amendment, you not only have a right as a candidate to communicate your views, but those who wish to receive it have a right to receive it. And that's where the MAGA caucus comes in. So they have a direct interest because their preferred candidate is being denied, they're being denied access to their preferred candidate, who has an undoubted right to run for election, even if he were a felon. We are going to present that amicus brief, and we are going to argue, and we are going to argue as many have with amici in the past. We're going to do it eloquently. We're going to do it with brilliance, and we are going to convince them. And what does an amicus do? An amicus is not a party to a case. The court can look at an amicus brief or not in its discretion. But the fact of the matter is, time and again, in critical cases like this one, courts have looked to amici to give them information, background information and details, effect information about the full effects of a decision, as well as detailed understanding of aspects of both constitutional and statutory law that may not be fully addressed by the parties.
Emord's involvement underscores the broader implications of Trump's conviction for our republic. As he stated in a press release, law and legal procedure are precedential, and if they can do it to President Trump, they can do it to anyone. So this legal battle is shaping up to be a defining moment for our nation. On one side, we have New York's prosecutors who claim that they're upholding the law. On the other, we have Missouri's Attorney General and figures like Emord arguing that this case threatens the very fabric of our democratic process. So as the story unfolds, one thing is clear. The outcome could have far-reaching consequences for the 2024 election and beyond. Will the Supreme Court step in? Can Trump's conviction be overturned? The answers to these questions could reshape our political landscape. If you got value from this report, tap subscribe. It's time for my final thought. Now, my friends, this is not just about Trump. It's about the integrity of our elections and the power of individual states. If New York's actions stand, it could set a dangerous precedent where any state could effectively veto a candidate they don't like. That's not how our republic works. Whether you're red, blue, or purple, this affects your right to choose your president. We're witnessing a pivotal moment in American history, so stay informed, stay engaged, because your voice and your vote have never mattered more.
Congratulations, you made it to the end of the video. Now keep up your quest for truth with this next news report. And if you found our channel enlightening, join the millions who agree with you. Tap subscribe. Thank you for watching the Next News Network.